All right, I see a few more people joining us. Excuse me, I know it's a couple minutes past 1. I'm just going to give it another minute or so, and then I'm going to jump in, be conscientious of everybody's time. We are in webinar mode. So just to confirm, if somebody wouldn't mind in the chat function, confirming for me that they're able to see the whole screen with the entire presentation on it, or are you seeing my screen with a short presentation and then the follow-up slides? Excellent. Thank you, Jan. Wonderful. Thank you, Holly. Excellent. Sometimes even a couple years into the pandemic, I'm still struggling every now and again with the tech. All right, we are ready to fully launch. Here we go. Welcome everybody to our presentation today on how to manage ADA, which is Americans with Disabilities Act, in the workplace. We had a lot of people interested in this topic, which I think is great. And I think it also speaks to a lot of what we're probably seeing, what I'll call post-pandemic or post the main portion of the COVID-19 pandemic and what's happening in the workforce. Next. This presentation is going to be recorded, so we will be able to provide access to you after the training. Everyone who's registered will be able to get this emailed to them, a link to log in and look back, download and save it. Our beautiful disclaimer, this presentation is provided for education purposes only. ADA is very specific. There are a lot of things that need to be taken into accommodation when you're thinking about accommodation. So I would definitely say make sure if you're really wondering about certain things, address it with your HR team. You can reach out to us, or of course you can reach out to a legal attorney who can help you through some of these processes. We're not going to go into anything hyper specific today. I can absolutely answer some questions on a general basis, but it's important to recognize that we are not legal attorneys, so I do have to be conscientious about giving legal advice. Who we are, a brief synopsis. BlueLion is an HR outsourcing organization. We're located in New England. All of our staff are on our East Coast, Upper New England region. This is our beautiful team right here. We just took this photo this past January. Our team has grown significantly. Cheers to our photographer for getting all these women in the photo to look good and like their photo. We also provide a 1% pledge. So we're really important to us is our 1% of our profits, services, and our time is rededicated to our community. So that's a really great thing that we like to focus on. We want to encourage other people to do. And so we like to talk about that quite a bit. My name is Toni. I'll be your presenter today. My background has always been in human resources. I have both an undergrad and a master's in HR from Southern New Hampshire University out of Manchester, New Hampshire. I am also certified by both SHRM and HRCI for both my SHRM CP and my PHR. I am the co-founder of BlueLion with my business partner, Allison. Now to the stuff you really care about, our agenda. So today we're going to do an overview of what the ADA is, examples of qualifying physical and mental disabilities, what you as an employer are required to do, what is the reasonable accommodation process look like, do you need proof of certain disabilities through documentation, what's classified as a disclosure from the employee to you as a disability, active dialogue, defining that, and how you can accommodate and make a plan of action to meet those requests. So an overview of the Americans with Disabilities Act. This absolutely has grown over time since 1990 when it was enacted. There's been amended, as you can see here, in 2008. But what it generally does is it provides employees with the ability to be protected in the workforce if they have a mental or now a physical and now a mental disability. So what that means is if they come into the workforce, we need to be able to treat them equally across the board when it comes to hiring, promoting, providing training, if there's layoffs or any additional kind of workforce opportunity that we're giving them. So the ADA has transformed how we look at people in a positive way, I would say, because it guarantees that people with disabilities have the same opportunities as everyone else to enjoy employment opportunities, as well as other things like purchasing goods, access to different kinds of buildings, government programs. It also protects them against discrimination based on these particular disabilities or perceived disabilities. So we'll talk a little bit about that as well. And it requires you as the employer to provide a reasonable accommodation to the qualified person that is within a specific guideline. And we will talk about that because I know when employers hear that you're required to give an accommodation, instantly, I think people think, so no matter what they request, I have to give it to them. And that's not necessarily the case. But more education on how it works, I think will give you the tools in order to be able to process this more thoroughly and make sure you're in compliance with what the guidelines require. So it is a law that applies to companies that have 15 or more employees. So if you are below the 15 threshold, technically the Americans with Disabilities Act, which is a federal law, does not apply to you. However, it's important to remember that certain states have additional protections for people who have disabilities that may be covered under their own disability act. So make sure you pay attention to that. But when it comes to the federal side of things, they kick in at that 15 employee count. Doesn't matter if it's full-time or part-time, 15 human lives inside your workforce, and automatically you get kicked into the ADA guideline requirements. So here are a couple examples of qualifying physical or mental impairments. Some we really talk heavily now about things that can't necessarily be seen. So certain things, for example, that are mental health disabilities are not necessarily as visible as physical disability. If somebody came into your place of employment, tried to be hired, they were in a wheelchair, instantly in your mind, you would say, okay, this person's in a wheelchair, they might need accommodations. Not necessarily when we're dealing with the mental health side of things, do we know that up front, nor can we ask that up front. So there's a lot of things here that you can see that do cover somebody under a disability. So things that you probably would think, of course, would be things like deafness, blindness, intellectual disabilities, or things such as dyslexia. Some people don't realize that that absolutely is a disability, that at times, if you're working certain kinds of jobs, you would need an accommodation to help on some platform or some front. Mobility impairments, that might be somebody who has maybe a prosthetic or has some kind of a limp or another kind of situation that may make their movements a little bit impaired. Major depression is a mental illness. We see here bipolar disorder, autism, obsessive compulsive disorder, post-traumatic stress. And then one that I do like to talk about actually that people don't remember all the time or think about is alcoholism. Alcoholism is absolutely something that is covered under the Americans with Disabilities Act. A lot of people are like, what? That's crazy. But realistically, it is an addiction. And since alcohol is not an illegal substance, it is covered under the ADA. So figuring out how to work that, we can discuss a little bit later to share that information more thoroughly. In my presentations, I generally like to add in unique cartoons that have to do with it. So here's a unique one, why, yes, we're an equal opportunity wrecking company. So the one reason that I thought this particular thing was funny is we personally at BlueLion do a lot of business with blue collar companies. And oftentimes if there is a physical impairment, you physically cannot necessarily do the job. So we do like to say, yes, of course, there's certain things that you're required to do in order to give that accommodation. But realistically, there are certain jobs that on a safety level, it becomes a threshold sometimes where you physically, no matter what we offer to you, would be able to do the job. It's not really an accommodation that would exist. And that has to do with what we like to call the bona fide job requirements. And it's really heavy on listing out those job descriptions and making sure that those job descriptions make sense, that they are defined legally under the ADA if you have to comply with that, and that you're outlining exactly what is required no matter what has to be met. So those are the things that you would have to provide accommodations for or not. So it was a funny one where you see somebody in a wheelchair who clearly realistically would never have a wrecking ball attached to them, making it an equal opportunity situation. So are you required to provide a reasonable accommodation? This is that 15-person threshold. Some states and local laws, as I said, may have required a lower threshold of an employee count in order to meet their own state level ADA requirements, and checking with your own state Department of Labor is important to see if your state complies with that. So if you're a 15 or above, yes, this presentation is specifically for you. I would say even if you are 15 or 14 or below, this is a best practice that we're going to outline here, so you can still apply it if you would like to, if you're below that threshold and you maybe hit a state specific outline. Reasonable accommodation process, first step always starts with the disclosure of the disability. So as an employer, you are not required by law to make an assumption on somebody's disability. Oftentimes we have in our application for employment, it might say something to the effect, which is absolutely all right. Are you able to meet the job functions with or without a reasonable accommodation? And so most people hit yes, because they would be able, if they're applying for the job, you hope to be able to do the job with or without a reasonable accommodation. But sometimes people may start a job and those disabilities that I spoke about earlier that might be mental health related are not necessarily ones that they started the job with. Sometimes it's something that can come up over time, or heaven forbid, somebody starts a job, and then while employed, they are in an accident or some kind of situation occurs and they physically become impaired in some way, shape, or form. So the first step in the reasonable accommodation process is the disclosure of the disability to the employer. Now, I have the comment here that as employers are only required to accommodate disabilities of which they are aware of. There's an asterisk, and here's why. There have been times in legal court hearings where there has been action taken against an employee who has a disability. They physically never told their employer that they had the disability. However, there were certain things that were visually seen by the employer throughout the employment where they were addressing performance that the employer should have recognized something was happening. What does that look like, for example? We see it through the court hearings, several court hearings, where it was employees who were requesting to take time off for medical conditions. The employer was addressing performance issues, was not tying in the question of a leave to those possible issues. And what ended up happening is they turned them on performance, and those medical issues were in fact the reason that some of that performance was lacking. So sometimes when there's leave issues, it's important to ask a little bit more of why someone might need that leave. Is it due to a medical condition? Is it a short-term medical condition, long-term, chronic? And getting that information, because if you do get that information, you're able to come forward and say, okay, you could qualify under the Americans with Disabilities Act. Let's start the next process. It is not your job to make an assumption off of somebody if they might have a mental health disorder. You don't need to say, oh, you know, Susan comes into work every day and she's always down in the slumps. I think she's got depression. I would definitely make this face and get a little worried. Please don't necessarily say it. Check in on Susan if Susan's having a rough day, a rough week, but don't automatically jump to the conclusion that somebody who may be experiencing a couple of issues here and there automatically has a mental health disorder. It's definitely just as dangerous to make that assumption as it is to not make the assumption, kind of. So it's important to note the process must be interactive. So it's a lot of back and forth between you, the employer, and the employee. It's participation on both sides though. So I say that because there are times that the employee refuses to engage in this process. And I have seen that happen both personally and with other HR people that I'm connected closely with, where you are trying your best as the employer to engage with the employee, give them the appropriate information they need to engage back with you, asking the right questions, and the employee either refuses to admit that there's an issue, refuses to get the proper medical documentation or additional documentation you're requesting, or just absolutely doesn't want to engage in this process because it's too much for them to deal with. It doesn't necessarily 100% negate the employer responsibility, but it absolutely, if necessary, gives you a lot more power on the back end if it becomes a performance issue that you can address as is necessary. Feel free to throw questions, by the way, if I didn't say this in the beginning, into the chat box or the Q&A box, and I can answer them as we go if it's something specific that I've gone over, or if it's something that you're having a question on and you don't want to forget for later. So here is an interesting one that, again, I like to throw these in. So the downtown post office, this is not obviously employee specific, but it could be if she was an employee of the downtown post office walking here, non-walking back door. So we do have to be careful with some of our accommodations, depending on what they are, to make sure that even in our accommodation, we're not humiliating somebody or making it difficult for them to meet those accommodations, or uncomfortable, or singling them out in a way that puts them in the limelight in a negative way. Buildings that are both government related, federally and state, are required to provide certain things like ramps and other things for employees to be able to engage, and for people who are utilizing their services to engage in those buildings. Not necessarily is that as easy in an employer side, but it is required if you are a federal organization. So now they've told you that they possibly have a disability, or that they believe that they have a perceived disability. Does the employee need proof or documentation of the disability? If the need for an accommodation is not obvious, so this is where I kind of go back to the mental health side of things, and I really heavily focus on that during this training, the mental health side, because it is very easy, quite honestly, to see somebody who has a physical impairment and their request for an accommodation is usually very simple as I need a ramp, or I need 10 minutes ahead of a meeting in order to get up the stairs if they're capable of taking stairs, or some other kind of accommodation. In order for them, I need a special chair, a special keyboard, I need to be able to stand when I'm at work, I need to be able to have special access to the restrooms. Whatever that may be for a physical impairment is usually visible and easy to work with. When we talk about the mental health side of things, what an employee may need in order to do their job when it comes to a mental impairment is a little bit more difficult, and usually requires definite information from a mental health or a medical professional. So if the need for the accommodation is not obvious, and that's why I say obvious, usually physical impairments are obvious, the employee may be required to provide documentation of a disability for the appropriate health or rehab professional to their employer. This must be done in a timely manner. You can make your own documents. What I suggest, if you are going to make your own ADA documents, is mirror them off of the Federal Medical Leave Act documents. And I say this because FMLA is something you can very easily go onto the federal website and download documents for when it comes to a medical certification and any accommodation that's required. The federal government has made this document and says the information on the document is necessary and important and okay for the employer to know. Because of that, I like to mirror my documents off of what the federal government has already said is okay. It's kind of like, don't reinvent the wheel in my mind. So if you do invent your own documents for the ADA, because unfortunately there are not a standard document for this, you would hope there would be, but there isn't. I like to say mirror that document. Also make sure that you have that job description, because when you're sending an employee back to their medical health provider and you're saying, listen, Bill, we recognize that you've shared with us you have a disability you're trying to have an accommodation for. Here is the medical documentation we need you to bring to your doctor in order for them to complete and tell us how we best can engage with you to make sure you can meet the job requirements effectively. The doctor is not going to know what Bill's job is. The doctor is not going to know, does Bill have to lift? Does Bill have to sit all day? Does Bill have to talk on the phone? Does Bill have to get up and down? Does Bill have to drive? Your job description has to outline that for them to recognize there's lifting restrictions, sitting, squatting, standing, long periods of walking, and they need to outline that very clearly so that when they bring that to the doctor, they can say, okay, I can recognize you can do these things, but these things you can't do. You would need an accommodation for. The next piece is the timely manner piece. So technically, again, by law, there is no specific hyper threshold like there is in the Family Medical Leave Act. But we have seen through court hearings what a general best practice and standard that is currently accepted is, and it's the 215. So your initial request to the employee, once they've disclosed to you that they have a disability, to provide you with a request or a medical document on what is needed then that is the first step. Sorry. The second, so when they get that document, give them 15 days in order to return it to you, the initial step. At that 15-day mark, if they haven't provided it back to you, give them another 15-day grace period. Let them know we're giving you another 15 days to provide us with this paperwork in order for us to meet the accommodation. We are trying to engage in the interactive process. That's the employer side. You're trying to engage. We need the information. We need you to provide us with what's going on so that we can get the information back and hit the next step of what that accommodation looks like. If you've hit those 215 timelines and the employee still does not give you the documentation, at that point in time, you don't need to continue to follow up every 15 days. And a lot of times when we're talking about ADA and why we're trying to manage ADA the way we do, it's to make sure that if we're dealing with performance related issues, we're not holding the employee accountable to things that they cannot meet without that accommodation. So if you're writing somebody up because they are having issues focusing, or they're having issues being able to take appropriate notes or follow up, or there's attention to detail issues, and maybe you find out, okay, they have dyslexia, or there's something else that maybe is creating a barrier for them to hit that target. That is why we want to make sure that we're paying attention to the ADA when it comes to performance, so that we're not discriminating against an employee for something that they might not have access to approve or provide a better process for without assistance. So that's the next step, is the 215s. Then there's the disclosure. So after an employee discloses the disability to the manager, right, to the human resources, whoever it may be, make sure you're telling your managers that if they're informed by an employee that there's a disability or a possible perceived disability, that they let the next person who's supposed to be managing this know. There have been issues in employer offices where a manager was informed, they forgot, they let it go, they thought no big deal, they didn't inform HR or the owner or whoever the next person, office manager, CFO, whoever it may be in your office that manages this issue. Then they got passed off, the employee was dealing with somebody else, they got let go, and all of a sudden, bang, discrimination, because the manager knew, didn't tell anybody, and we didn't engage in the ADA interactive process. So it's really important to train our managers that if they are informed of a potential or a disability, that they bring that to your attention. So the disclosure is just an example, usually takes the form of, because of my disability, I'm having trouble with X, Y, and Z in my job function, or whatever it may be, benefits, or whatever it may be for employment. I can't drive, or I can't go somewhere to hit the trainings, or trainings virtual. Whatever that might look like is usually a first conversation. For an employee to disclose that they have a disability without also saying that it's impacting their work is usually not sufficient to begin necessarily the accommodation process. So just because Jim comes forward and says, hi, HR, I just want to let you know I'm seeing a doctor for my anxiety, you don't then need to initially say, okay, Jim, do you need an accommodation? An accommodation for what? If Jim is doing all right at work, there's no issues, Jim doesn't think that there's a situation he needs to be getting an accommodation for, you don't need to engage in the conversation. It's when they bring up that it's impacting their work, or when you're engaging with them on a performance issue, and at that point in time, that's usually when we see it, they tell you that something is happening on the back end that's impacting their work. That's when the accommodation needs to happen. Because I'm sure there's many of us, some of us personally right now, or that we have engaged with, who have people who have disabilities, but they don't necessarily need an accommodation because they self-accommodate. Maybe it's something they recognize they need to give themselves something, and they already do it, and it's not necessarily something that the employer needs to provide to them. Here's a Dilbert, who's one of my favorite cartoons for an HR person. Really funny if you've never heard of Dilbert. He does a lot of cartoons, but he does a lot of HR ones, which are fun. I need to take an extended medical leave to deal with my job-related stress. I've heard this actually be requested. The stress is degrading my cardiovascular system. I could drop dead any minute. Which part of your job is causing stress? I think it's the work part. So for any of us that are dealing right now with recruiting issues, and you're seeing on the news, on social media, whatever it may be, finding people who want to work as hard, This is kind of a little bit of a poke at that, but at the same time, there are absolutely people who have needed a leave of absence from their place of employment because the stress of their place of employment has truthfully given them a medical condition. I personally have seen it, where just the stress of a job has created somebody's physical, has represented in a physical way for an employee. And the doctor absolutely was able to say, they've been healthy this whole time. They started working here 6 months ago. All of a sudden, we're having these issues. It could be a short-term leave. Sometimes maybe it's just somebody disconnecting. Maybe it's looking at the job itself, seeing what's going on there. Maybe it's something underlying that we also need to recognize that's more employment related, not necessarily employee related. Is our processes making sense? Do our teams make sense? Is there a manager who maybe is having a little bit of a hostile situation here? So that's kind of the conversation. But in general, being stressed at work is not something that you would have to worry about dealing with under the ADA in general, because good Lord, I don't know, 2 years past COVID, one person who's not stressed at work. So we've established an active dialogue with our employee. What does that look like? Documentation is what it looks like. I say it all the time and I will say it till I pass out. It's important to document the conversation. I know that's hard when you think about how do I document a verbal conversation? Write it down in an email, follow up with an email to that employee. Hi, Susan. Hi, Bill. Hi, Dan. Thank you so much for coming in and sharing. You don't necessarily need to divulge in the email. You can if it's a confidential email system, but you can say, thank you for sharing with me that there's a situation that you're looking for an accommodation. As we spoke about, I've attached the documents here, or I had given you the documents in my office. Please make sure you get them back to me on this particular date. If there's anything between now and then that we can do to make this process easier, please let us know. Document your side of things. Print off a piece of paper. It can be on computer paper. It does not need to be some crazy formal process, as long as it's documented in one way, shape, or form. So the goal of the dialogue is to understand what is the barrier that the employee is dealing with. And then it is also helpful to see if the person has any ideas of what they think is useful. Do not start on your end as the employer providing a solution. Let the employee tell you what they need first. And then we can talk about whether or not it is something we can accommodate and will accommodate. But do not just jump in and say, here's what we can do. That's not interactive. Interactive is back and forth. So they told you that they have a disability. You said, thank you for sharing. Basically, great. Here's paperwork. What can we do? They share with you what you can do as the employer. So the employer should also provide an overview of this process. Tell them how the Americans with Disabilities Act works. Let them know this is interactive. Thank you for bringing this to me. Here's how this works for us. Depending on the disability, as I said, if it's somebody in a wheelchair, you probably wouldn't need medical documentation for that. But depending on the person, you say, hey, we would need the follow-up medical documentation. We are going to give you 15 days in order to get it. If you don't think that's enough time, tell us and we can give you a longer timeline. We want to work with you. Once we get back what you think some of these accommodations may be that you need, we are going to discuss it as a leadership team and see how we can accommodate you best. We want to make sure that you're successful here. We want to make sure that you are here long-term. You're a good employee. Hopefully they're good employees. And we want to make this work for you. Depending on what you bring back to us, we may not necessarily be able to hit everything you're looking for, but we will go back and forth to make sure we try our best to find something. That's important for the employee to recognize. You are going to do your best on the employer side to give them the opportunity for success with whatever that disability may be. Confidentiality when discussing the accommodations, reasonable accommodations, information may also be shared on a need-to-know basis. So you don't need to tell everybody in the office that so-and-so came forward and told you something happened, but you absolutely can tell the manager. You don't necessarily, depending on the manager's interaction with the employee or their interaction with you, need to tell them what the disability is. You can very easily say, hey, so-and-so, Alex came to me today and informed me that she's dealing with some mental health issues and she may need an accommodation because they're affecting her ability to focus at work. I'm not sure if you've seen any of the performance issues that I've seen, but we are going to see what she needs in order to accommodate her. Let me know if there's anything you would like me to pay attention to. You don't need to necessarily say, hey, so-and-so Alex came forward and told me that she has OCD, anxiety, and depression, or that she's on a medication, or she's seen a therapist. You don't need to divulge more than you need to divulge, if that makes sense. I equate it very similarly also to a lawyer standpoint. I laugh if anyone has seen even the slightest tidbit of the Johnny Depp cases. Ask and answer. Only answer the question being asked to you. Don't go over the question. Just what's the question? Instantly, what's the answer? You don't need to give too much backstory unless they ask and if you think it's appropriate. So paying attention to that is important. You want to make sure employees' confidentiality is kept. If they want to share, that's their information, but you want to protect on the HIPAA side of things. Coworkers who may need to do something differently as a result of an accommodation may be told of the change required, but should not be told of why the requirement is being changed. Most of us are working in small organizations. Most employees know everything about each other. So will the employees likely know why an accommodation is being made or why they need to shift a way that they're doing a work process? Maybe, probably, most likely. But that doesn't necessarily mean that you as the person who's managing this process needs to be the person giving that information. The person who is looking for the accommodation has the right to do that. And that's really it. If an employee asks, you can say, this is the process that's just going to make it a little bit more accessible for everyone to succeed, and leave it at that. It does not matter. This is our new way. And hopefully the employees will accept that with grace, and they'll recognize that in order for their team to be more successful, they'll do the new process. So as an employer, how do I accommodate an employee with a disability? Well, this is one of those lawyer asterisks, of course, as well, that they tell us. It depends. It depends on what the accommodation is. But here's a couple examples of what we've seen and what people generally do or are requesting. So a change of job tasks, providing reserved parking, something close, they don't have to walk far, improved accessibility to the work areas, changing the presentation of tests and training materials. This has to do with maybe they have a learning disability, the way that they accept information is a little bit different. Providing or adjusting a product, equipment, or software. So if somebody needs, their chair to be a little bit different or their desk setup ergonomically to be a little bit different, putting that into place. Allowing a flexible work schedule could sometimes be an accommodation, or providing a leave of absence. I know it seems weird that letting the employee leave work for a short period of time makes sense as an accommodation for them to do their job better, but it is. So we see a lot of requests for leave of absence when it comes to somebody, for example, as I went back to the beginning, who might be dealing with an alcohol misuse disorder. So if they're dealing with that, sometimes people need to go into a rehabilitation. So they may ask for some time off in order to accommodate that. Under the alcoholism side of things, an employee does not get to show up to work under the influence of alcohol and have it be covered under the Americans with Disabilities Act. No, they cannot come to work late because they have been on a bender all night. No, they cannot leave midday and get drunk and come back to work and then not do their job well. Also a no. What could be an accommodation for somebody who might be dealing with alcohol addiction? A specific time in the day that they need to leave in order to see their sponsor, or if they need to join virtually on a Zoom because there is an AA meeting, or they need a couple weeks off to go into a rehab treatment center. Those types of things are the things that assist them with getting back to work and being able to do their work and stay with the company long-term and more positively. There are people who have chronic illnesses, for example, like gout, that is considered a disability. For them, flexible work schedule could be the accommodation. Anyone who knows or has maybe had someone or has themselves dealt with gout, you don't know you're having a flare up with gout until it happens in the morning of or midday. And all of a sudden you can't stand, you're in pain, you need to go home, you need to be on medicine or dealing with something else. Giving them a flexible work schedule allows them to meet those accommodations as long as you tell them, okay, well, make sure you come back in and get your other stuff done, so on and so forth. And usually when those people have that flexible work schedule, they can manage a little bit more efficiently. So then the next step and the final step, once we've been informed that we have an employee who has a disability, we've asked them for any documentation if necessary. They've shared with us now what the accommodation is. Here's my accommodation, either from me or from my doctor. Now we establish a plan based on what we can approve. So in the end, it is the employer who decides what accommodation they get to put into place, but it must be effective to resolve the issue presented by the disability. So establishing that plan and putting it into place and writing it down and what the expectation is of that plan is important. So for example, the employee who is dealing with gout doesn't just get to not show up to work. Our flexible work schedule for you is if there's a situation in a flare-up, you got to notify your manager and then let your next step manager know so that they can get the proper coverage or whatever it might look like to make sense for the other people in the organization. If you plan to deny an accommodation request, you need to have a real good reason on why you are denying it. A real good reason. Most accommodations people try and claim are costly, which creates the undue hardship. Almost every time that hits a court hearing, the employer loses because the actual cost of making the accommodation is considerably less than what the employee makes, what the company takes home as profit, meaning not revenue, money in pocket after tax at the end of the day, and the company just doesn't want to deal with the process. Back to the meme in the beginning or the cartoon in the beginning, if the company truthfully cannot make the accommodation or the accommodation doesn't exist, then it is impossible for them to continue to do their bona fide job qualifications. And I see that a lot more when it comes to jobs that require physicality in nature. So if you're required as a landscaper to work a particular piece of machinery, and in order to work that machinery, you need to have appropriate feelings in your hands and your feet, and you have a disability where you don't have the appropriate kind of sensitivity feelings in your hands and feet, there's no accommodation that can give you feeling in your hands and feet. And there's no retrofitted equipment likely that is going to be able to provide you with what is necessary to do that job. So that would be an unreasonable accommodation. You cannot meet the qualifications with and without an accommodation. So there are times that you can't accommodate, but not because you don't want to and not because of quote unquote undue hardship. So as the employer, you want to continue to communicate with the employee in a timely fashion. Don't let weeks and gosh, don't let months go by before you follow back up with that employee on what's going on. Make sure you're paying attention, letting them know that the discussion is happening and meeting a couple accommodations along the way when you're making the final decisions. Documentation again, document the dates, document the actions, the conversations, who was involved, why decisions were made. If it takes a small step, like, okay, we're going to start with maybe a flexible schedule until you get the hang of something, and we're going to readdress it in a short period of time. Sometimes accommodations are short-lived. They're not necessarily the lifelong of the employee's tenure with the organization. So paying attention to doctor's notes, is this a 60-day follow-up? Is it a 90-day follow-up? Are we talking 6 months or a year? And paying attention to that information. I had an employee once who had a heart attack. They were out of work for a short period of time, about 3 months. When they came back to work, they needed short breaks throughout their day in order to stand up and walk around for their cardio health. It was an easy accommodation, 10 minutes, like every 2 hours, easy peasy, lemon squeezy, no big deal. We had that employee get that accommodation. After about 6 months, she didn't need it anymore. The doctor said, no, you should be okay. We encouraged her to still stand up and walk around. I said, well, I think it's still a good idea. But realistically, she didn't need it. So we needed to let the team know there are times where this employee is not going to be on the customer service phones during the day because they're going to be clocked out to do, 10 minutes walk around their house that was remote work from home. You hope they're doing what you've given them the time to do. But that was the accommodation that that particular employee needed in order to do their job effectively. And in conclusion of processing ADA, we've outlined the timeline. We've outlined how long this conversation may take, the 215s, when it comes to creating documentation and collecting it back. What you need to do when it comes to documenting the conversation and process. The asterisk of paying attention if you think that there's a situation with an employee and you want to dig just a little bit deeper to see what's going on. Not offering up an initial solution to the employee's accommodation need, and not assuming somebody has an accommodation need just because they bring to you something that you may deem as a disability. So it is a violation of the ADA to fail to provide an accommodation to the known physical or mental limitation of a qualified individual unless it would impose undue hardship. Again, the threshold for undue hardship is very high, very high. So you really would, like I said, have to have something crazy, like the cost of putting in, for example, an elevator. That was the only thing that could be done. And it's an old building, maybe you don't own it. You have to move the building, the whole thing. So that might be one thing if that's the only accommodation that could be met. But oftentimes it's not necessarily the only accommodation, which is why the interactive process is so important, because it takes a couple heads to come up with the solution to make sure that the employee can be successful. And now we are open for questions. So you can either throw your question into the chat box, you can throw it into the Q&A function, whichever works easiest for you. You can go specific as you like, or you can go as general, whatever works. I want to leave it open for a few minutes in order for you to be able to put that information in here. While I'm waiting for any questions, I hope this training was helpful to you on how to manage ADA. I hope it was important on making sure that you can access the information appropriately. And if you need more assistance after the fact on something very specific to your place of employment, you're dealing with an ADA issue and you want to know how to manage it, our contact information will be on the next screen in order for you to reach out to us. As you saw, we have a large team of HR professionals who deal with these kinds of situations on a day-to-day basis. And we can definitely walk you through whatever situation. And if there's anything that is completely above something that we're capable of, we have phenomenal attorneys we work with, or we can always encourage you to go back to your own attorney. No one has shot everything into the quick Q&A or the chat box. So either I did a great job or I lost most of you during the training. I'm hopeful for the first one. But if you do want to connect with us, please do so. This is our phone number, our email, and it's a great way if you follow us through social or sign up for our newsletter to get updated blogs that we write weekly, trainings like these that we provide monthly for our team and our community as a whole. And just fun, quick tips and tricks as our team as well. Thank you all so much and have a fantastic rest of your evening.